Hey, sir, so I saw what you said about having a uniform and like a suit and stuff, but I actually left my uniform at school and I don't have a suit, so this is the best thing I got. And then, so my partner's Jerice, and we're the crown in this case. So my part starts with summarizing the trial judge's decision. So I'm just going to start there. The learned sentencing judge carefully considered the appellant's arguments on each of the foregoing points and properly rejected each of them. With respect to Section 12 of the Charter, the learned sentencing judge correctly noted that to constitute cruel and unusual treatment or punishment, it is not enough that a sentence be merely excessive, it must be so excessive as to outrage standards of decency and be abhorrent or intolerable. The sentencing judge found that this is a very high threshold, that this very high threshold was not met on the facts of this case. As for Section 15 of the Charter, the learned judge correctly instructed himself on the governing legal principles as set out by the Supreme Court of Canada. He concluded that the mandatory minimum is universal in its application and does not cause any disproportionate impact on Aboriginal offenders. He therefore correctly concluded that Section 15 of the Charter was not infringed. Although he did not find any infringement of Section 12 or 15, the learned judge nevertheless considered the potential application of Section 1. After considering the leading cases, the judge rightfully noted that the court is not a legislature and it is not part of the court's role to assume a legislative function. Provided that an infringement is reasonable, the court must not undermine the pressing and substantial goals advanced by the legislation by second-guessing the will of Parliament. So then finally, the judge below rejected the appellant's assertion that the mandatory minimum sentence violates his Aboriginal rights. Specifically, he correctly noted, whatever the use of Mi'kmaq First Nations may have made of restorative justice principles in the time prior to European contact, those principles have never been recognized as amounting to a right within the meaning of Section 35. Having correctly rejected each of the appellant's arguments, the judge imposed the mandatory minimum sentence as required by law. So that was that was the first part that I wrote. And then the next part that I wrote was I wrote about issue 1. So I'm just going to start reading issue 1 now. Section 5.3a.2 of the CDSA does not violate the appellant's Section 12 charter rights. Section 12 provides that everyone has the right not to be subject to any cruel and unusual treatment or punishment. The only way the appellant can win his challenge is if he can show that his sentence is grossly disproportionate. But as the Supreme Court of Canada emphasized in the leading case, R.V. Willis, for a sentence to be considered grossly disproportionate, the sentence must be more than merely excessive. The sentence must be so excessive as to outrage the standards of decency and disproportionate the extent that Canadians would find the punishment abhorrent or intolerable. The mandatory minimum of 2 years is not a grossly disproportionate sentence for 2 reasons. Firstly, drugs can be very dangerous. They kill a lot of people. More than 750,000 people have died from drug overdoses since 2000. Also, drugs can be especially dangerous for children, as can be seen from the fact that the child had to be rushed to the hospital in this case. Also, the appellant argues that the mandatory minimum sentence displaces Gladue principles, but the Supreme Court R.V. Gladue ruling would still be used. It just can't be used to go below the minimum. If the appellant was not Aboriginal, he might have been sentenced to more than 2 years. In conclusion, it is clear that Section 12 has no bearing on this case. So then the next thing that was my part is I also did issue 2. So I'm just going to start issue 2 now. Section 5.3a.2 of the CDSA does not violate the appellant's Section 15 charter rights. Section 15 provides that every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. The appellant argues that Section 3A.2 of the CDSA and mandatory minimum sentencing in general prevents the realization of equality for Aboriginal peoples in the sentencing process, but this is not the case. It is clear that the appellant is wrong because he does not meet the standards set in the Supreme Court case Lovelace v. Ontario. First, we must examine whether the law, program, or activity imposes differential treatment between the claimant and others. Secondly, we must establish whether this differential treatment is based on one or more enumerated or acknowledged grounds. And finally, we must ask whether the impugnant law, program, or activity has a purpose or effect that is substantively discriminatory. The appellant does not meet the first step of this process because mandatory minimums do not impose differential treatment between the claimant and others. If anything, mandatory minimums make rulings more consistent and less subject to differential treatment. In conclusion, it is clear that Section 53A2 of the CDSA does not violate the applicant's Section 15 charter rights in any way. So that's my part. Thanks for listening. Have a nice day, sir.